Welcome. My name is Sarah Kendall, Chief of the USCIS Immigrant Investor Program Office, or IPO. Thank you for joining us for an online presentation with updates on the EB-5 Immigrant Investor Program, also known as the EB-5 program. The Immigrant Investor Program Office and all USCIS as a whole is committed to ensuring continuity of mission performance even as the nation struggles with the ongoing COVID pandemic. The pandemic is having an impact on IPO's normal business practices. In mid-March, USCIS, like many federal agencies, maximized telework. IPO staff have continued to work diligently, even in very constrained and unprecedented circumstances generated by the pandemic. They have adapted to the new environment, almost 100% telework. Our onboard staffing level currently consists of 232 dedicated people, including support staff, adjudicators, economists, fraud detection and national security personnel, compliance officers, and others vital to the performance of the IPO mission. The format of this video will consist of a presentation with program updates, followed by a question and answer session based on questions submitted in advance through our public engagement mailbox. I hope you find this format helpful. As always, we welcome the opportunity to engage with you.
In this presentation, we will share several updates on the USCIS Immigrant Investor Program Office, IPO, and the EB-5 program, including the visa availability approach for managing Form I-526 petition inventory, the policy manual, separate adjudication of I-829 principals and derivatives in some instances, program integrity, regional centers, and, finally, some operational changes on a few of the EB-5 form types adjudicated at IPO. Visa availability. As announced at IPO's last stakeholder engagement on March 13, 2020, effective March 31, 2020, USCIS implemented a process change for Form I-526, Immigrant Petition by Alien Investor, moving to a visa availability approach. Also, at the last engagement, Chief Sarah Kendall reviewed some questions and answers regarding this new process that were later posted on USCIS's website, uscis.gov/EB-5, under the EB-5 Resources heading. Since that time, USCIS has added additional Q&As on that same page in order to provide more information about our I-526 inventory management approach to the public. Although this approach prioritizes the assignment of Form I-526 petitions where visas are immediately available or soon to be available, thousands of Form I-526 petitions fall into this category. One of the new Q&As explains how IPO generally organizes its I-526 inventory based on this prioritization. We manage our pending I-526 inventory through workflows that factor in 1. Whether a visa is available or soon will be available, and 2. Whether the underlying project has been reviewed. In addition, IPO generally manages workflows in, first out order when a visa is available or will be available soon. IPO has put in place accountability measures to make sure these procedures are followed so that discipline is maintained in the new inventory management process. IPO is committed to managing its existing inventory in as equitable and efficient a manner as possible. Another new Q&A on the USCIS website addresses the methodology that the agency uses to calculate its processing times. The methodology currently used to calculate processing times is described in detail on the website at egov.uscis.gov/processing-times/more-info. The address is in the response of the Q&A for later reference, but in brief, it represents a range of processing times based on an analysis of recently completed cases. This methodology was applied to Form I-526 processing times in May of 2019. Because the current processing times reflect the age of recently adjudicated I-526 petitions, the range can fluctuate depending on the filing dates of petitions recently completed. On the subject of processing times, IPO has also updated the USCIS website to differentiate between the I-526 processing times for petitioners from China and the rest of the world. USCIS hopes these changes will help to provide additional clarity for stakeholders. Policy Manual Update. On July 24, 2020, USCIS announced a policy manual update clarifying initial and further deployments. First, the policy manual update clarifies that capital may be deployed directly or indirectly through any financial instrument, so long as it meets applicable requirements. Deployments of capital, both initial and further deployments, must satisfy applicable requirements to place the capital at risk, to include a risk of loss and a chance for gain, demonstrate the actual undertaking of business activity, demonstrate a sufficient relationship to commercial activity, that is, the exchange of goods or services, such that the enterprise is and remains commercial, and make the full amount of the investment available to the business or businesses most closely responsible for creating employment, if the job creation requirement has not already been met. The requirement to make the full amount of capital available to the business or businesses most closely responsible for creating employment is generally satisfied through the initial deployment of capital, resulting in the creation of the required number of jobs. Second, further deployments must occur within the framework of the initial bases of eligibility. This means that a deployment must be within the same new commercial enterprise, or NCE, the same regional center, and the same regional center's approved geographic area to include any amendments expanding the regional center's geographic area approved before the further deployment. Third, deployments must be consistent with the purpose of the NCE to engage in the ongoing conduct of lawful business. Finally, deployments must occur within a reasonable amount of time, which is generally considered 12 months. USCIS may consider longer periods reasonable under the totality of circumstances when there is supporting evidence. Separate adjudication of I-829 principles and derivatives. In July 2020, USCIS implemented a new functionality for I-829s that allows IPO to process a principal petitioner's I-829 petition separately from his or her associated family member or derivatives petition. In routine adjudication of the I-829, when the petitioner has established eligibility, USCIS approves the petitioner first, since the derivative's eligibility is based upon the petitioner. In the past, if required information for a derivative was missing, IPO would wait to issue a decision on the petitioner's eligibility until it resolved concerns about the missing information for the derivatives. With this updated functionality, IPO officers can approve the principal petitioner's Form I-829 while holding the adjudication of the petition's associated derivatives when there is missing information or other action is needed before a final determination can be made. IPO uses this new functionality if a derivative associated with an approvable I-829 is missing, for example, biometrics, or other information that affects eligibility, such as proof of relationship to the petitioner. Program integrity. Program integrity remains a vital component in ensuring the success of EB-5 projects. Program integrity is at the forefront of everything. USCIS continuously fields questions from Congress and others on performance in this area. IPO is committed to ensuring that benefits are only issued to eligible applicants and petitioners. Even with the most stringent safeguards in place, program integrity depends in part on the responsible actions of program participants. Those representing EB-5 parties could help by applying due diligence and ensuring clients they represent bona fide applications and petitions. Fraud and other public safety or national security concerns in the EB-5 program, regardless of when such concerns come to light, adversely affect the EB-5 program and the stakeholder community. IPO officers invest the necessary time and focus in conducting inquiries into such matters. Most petitions and regional centers are engaged in legitimate businesses and endeavor to strengthen U.S. communities by creating jobs. Unfortunately, instances of malfeasance and abuse by a few program participants have resulted in cases of substantial financial losses to investors. These cases also have a negative impact on local economies and program integrity generally. IPO has strong and committed partnerships with law enforcement agencies and financial regulators, and, in addition to our own inquiries, we support their civil and criminal investigations. An example of this kind of malfeasance can be seen in the recent sentencing of two individuals who misused foreign investor funds and defrauded USCIS. A federal jury convicted Jennifer Yang and her business partner, Daniel Wu, of visa fraud, mail fraud, aggravated identity theft, and conspiracy to commit all of the above in connection with a scheme to fraudulently obtain immigration benefits through the government's EB-5 visa program. In another case, January 26, 2021, is the sentencing date for two regional center principals who defrauded investors and USCIS. IPO drafted a victim impact statement, which has been filed with the court for consideration in sentencing, and USCIS leadership is providing a statement to the Department of Justice for inclusion in their press release on this case. If you suspect or would like to report an instance of fraud, please visit uscis.gov/report-fraud. You can click on the EB5 fraud link, and this will take you to information about reporting fraud in the EB5 program. It bears repeating that IPO and the EB5 stakeholder community share common goals. Maintaining program integrity is mutually beneficial and ensures program longevity. Regional Centers. The Regional Center program was recently extended until December 11, 2020. USCIS continues to heavily monitor compliance and will act when a regional center has failed to meet the terms and conditions of the EB5 program. As a reminder, IPO is currently in the middle of the annual filing period for Form I-924A, Annual Certification of Regional Center, which a regional center must file to demonstrate its continued eligibility as a designated regional center in the EB5 program. A regional center must file for the fiscal year that we approve the regional center and for every subsequent fiscal year between October 1st and December 29th, within 90 days after the end of the fiscal year. As required in 8 CFR 204.6 M6, to maintain status as a designated regional center, regional centers must provide information annually or as otherwise requested by USCIS. If a regional center fails to properly file Form I-924A, IPO will issue a notice of intent to terminate the participation of the regional center in the program, which may ultimately result in the termination of the approval and designation of the regional center. Last fiscal year, 105 regional centers failed to timely file the I-924A and received notices of intent to terminate. Of these regional centers, approximately 70% had their designation terminated. Please note that this year there are some changes to Forms I-924 and I-924A that recently became available. As of January 5, 2021, USCIS will no longer accept the old I-924 and I-924A forms. What does that mean? For example, if you file your I-924A before January 5, 2021, you may use the previous form with an edition date of 11/21/19 or the new forms with an edition date of July 23, 2020. You should follow the instructions on the USCIS website for filing instructions and fees. If you file late and file your I-924A on or after January 5, 2021, you must use the new version of the form with an edition date of July 23, 2020. You must file your form and fee according to the website instructions. The mailing address may be changing, so check the website to make sure that you are sending it to the correct address. Additional changes to the Form I-924A clarify that regional center principals must provide all other names the principal owner or non-owner has ever used, including aliases, maiden name, and nicknames. Regional centers must report the aggregate fees or other remittances that have been paid to the regional center or its principals, managing companies or agencies, or agents. This includes fees, profits, surcharges, and other remittances. As noted in the Form I-924 instructions, USCIS may require that you appear for an interview or provide biometrics, fingerprints, photograph, and/or signature, at any time to verify your identity, obtain additional information, and conduct background and security checks, including a check of criminal history records maintained by the FBI, before making a decision on your form. There are steps you can take to reduce the chances of receiving requests for clarification, requests for evidence, from USCIS regarding the Form I-924A, including the following. For one, make sure the information in the form is accurate, and that you complete the form entirely. If you do not complete the form according to the instructions, or if it contains incomplete or inaccurate data, we may issue a notice of intent to terminate for failure to provide required information. If there are inconsistencies between what is provided on the Form I-924A and what was previously provided to USCIS, take time to explain why something is different. The form instructions note that there are specific documents you must include in Form I-924A submissions. For example, regional centers must include government-issued photo identification for all principals. Last year, a significant number of submissions did not include the required photo identification. Please review the form requirements and make sure that your submission is complete. This review will save us time and you time. Regional centers must report changes to the center's name, ownership, organizational structure, principals, and geographic area, among other things, by properly filing a Form I-924 amendment and paying the associated fee. Submit a Form G-28 with your Form I-924A filing if you are represented by an attorney. Additional updates. Regarding I-526 and I-829 completions, during the 6-month period after building a more robust quality assurance and control program, IPO completed the adjudication of an average of 212 Form I-526 petitions each month from March 2019 through August 2019. This year, IPO is averaging 304 I-526 completions per month during the same 6-month period. This is an increase of approximately 43%. IPO has also improved upon I-829 completion rates. IPO averaged 157 I-829 completions per month for the 6-month period of March 2019 through August 2019. That average was 265 during the same period of 2020, an increase of approximately 68%. On the topic of processing times, IPO would like to provide background to the update to the I-924 processing times that occurred over the summer. Previously, terminations were included in the data that I-924 processing times were based on. If the dataset included a termination, the processing time would be calculated from the date of initial receipt of the initial I-924 to the date of termination. This adjusted the overall I-924 processing times as the period of time between the initial receipt of an I-924 and the termination date does not reflect the time an I-924 has been pending. We have removed the termination date from the calculation in the electronic system to more accurately reflect the actual processing time for a pending I-924 application. Please visit the USCIS website for FAQs, including those on the modernization rule that became effective on November 21, 2019, and questions on the visa availability inventory management approach for Form I-526 petitions that began March 31st.
We appreciate that so many of you took the time to submit questions through our public engagement mailbox. Due to time constraints, we are unable to respond to all of the questions. However, we selected some of the most prevalent questions to address and will be posting additional questions and answers to the website over time. You're always welcome to submit non-case specific questions to our public engagement mailbox at public.engagement@uscis.dhs.gov. Does the visa availability approach apply to a petitioner who has an approved Form I-526? No. The visa availability approach is IPO's inventory management approach for the assignment of pending Form I-526 petitions. How does the visa availability approach affect an investor from a rest of the world or ROW country with a historically small number of applicants? For petitioners with pending petitions and an available visa or a visa that will be available soon, IPO will prioritize the assignment of their Form I-526 petition before other Form I-526 petitions of investors without a visa available or soon to be available. What is the impact of how many months a visa could take to be issued, especially now that the United States embassies are not fully operational due to COVID-19 constraints? Visa issuance falls under the purview of the Department of State. For additional information on visa availability and processing times, please visit travel.state.gov. How is USCIS processing Hong Kong petitioners' cases under the visa availability approach? For purposes of the visa availability approach, USCIS will continue to look to the Department of State's monthly visa bulletin. USCIS compares a petitioner's country of birth to Chart B of the visa bulletin and uses this information, along with other factors, to determine which Form I-526 petitions should be processed first. Several investors have suffered temporary halts to construction projects due to COVID-19, and statewide restrictions. Is the IPO considering those when the investors have not proceeded with the business plan due to stoppage of construction? Kindly clarify what the position of the IPO is in these situations. Each situation is reviewed on a case-by-case basis and based on the individual facts of the particular case. However, while we acknowledge that the pandemic may affect business realities, the petitioner or applicant must still establish each eligibility requirement by a preponderance of the evidence. If the job creation is done and the project is benefiting the public, not just real estate developers, can you have a policy to ensure that investors will not need to reinvest in another project? The USCIS Policy Manual provides guidance on the capital at risk requirement, including the sustainment of that requirement through the conditional permanent residence period. A foreign national seeking EB-5 immigrant visa classification must have invested or be actively in the process of investing the required capital in a new commercial enterprise and create full-time employment for not fewer than 10 qualifying individuals. See INA 203b5. The foreign national's investment must be placed at risk. See 8 CFR 204.6J2. The immigrant investor must sustain the investment, including the at-risk requirement, throughout the 2 years of the immigrant's conditional residence. See INA 216A and USCIS Policy Manual, Volume 6, Part G, Chapter 5A2. With the current processing times for Form I-829, petition by investor to remove conditions on permanent resident status, will IPO consider extending the 18-month Conditional Lawful Permanent Resident, or CLPR, status on the I-829 receipt notice? At this time, USCIS is not considering extending the current 18-month CLPR status extension upon receipt of a properly filed I-829. What steps should a petitioner take to add an eligible derivative to a Form I-829? Petitioner should contact IPO's Inquiry Management Team at uscis.immigrant-investor-program@uscis.dhs.gov, placing, quote, request to add derivative to Form I-829, end quote, in the subject line. What steps should a petitioner take to resolve the improper rejection from lockbox staff of a request to add an eligible derivative to a Form I-829? Petitioner should contact IPO's Inquiry Management Team at uscis.immigrant-investor-program@uscis.dhs.gov if a petitioner believes a request to add derivative to Form I-829 was incorrectly rejected. Can investors receive their investment back after submitting the Form I-829 if they have met the eligibility requirements at the time of filing? To qualify for removal of the conditions on permanent residence, the immigrant investor must, in part, show that at least 10 full-time positions for qualifying employees have been created or will have been created within a reasonable time, and provide evidence that they sustained their investment throughout the period of their status as a conditional permanent resident. USCIS reviews the investor's evidence to ensure sustainment of the investment for 2 years from the date the investor obtained conditional permanent residence. Since the immigrant investor must submit Form I-829 within the 90-day period preceding the second anniversary of obtaining conditional permanent resident status, filing Form I-829 may not necessarily account for the entirety of the investor's required sustainment period. In cases with a similar fact pattern, the required 10 jobs may not have been created, or the record may not demonstrate that the requisite jobs will be created within a reasonable time, which may result in the denial of the Form I-829. What can a denied Form I-829 petitioner do to ensure that USCIS properly extends their I-551? The regulations state that if USCIS denies the Form I-829 petition, USCIS will provide written notice to the investor of the decision and the reasons therefor, and shall issue a notice to appear. The investor's lawful permanent resident status and that of his or her spouse and any children shall be terminated as of the date of USCIS's written decision. No appeal shall lie from this decision with USCIS. However, the investor may seek review of the decision in removal proceedings. As an immigrant investor whose Form I-829 has been denied may seek review of the denial in removal proceedings, USCIS issues a temporary Form I-551 until an order of removal becomes administratively final. An order of removal is administratively final if the decision is not appealed, or if appealed when the appeal is dismissed by the Board of Immigration Appeals. Would a Form I-829 case adjudication be affected by the termination of its sponsoring regional center if all other requirements have been met, such as job creation and so forth? It depends on the facts of the case. An immigrant investor's conditional permanent resident status, if already obtained, is not automatically terminated if the investor has invested in a new commercial enterprise associated with a regional center that USCIS terminates. The investor will continue to have the opportunity to demonstrate compliance with EB-5 program requirements, including through reliance on indirect job creation. However, there are times when a regional center has failed to promote economic growth and its designation is consequently terminated may have a bearing on the I-829 adjudication. For example, depending on the facts of a particular case, if a regional center was terminated and there was evidence of misappropriation, such evidence could undermine the petitioner's ability to make the showings required under 8 CFR 216.6. In such a scenario, it is not the termination of the sponsoring regional center that is affecting the I-829 adjudication, but rather an evaluation of the applicable eligibility requirements. How long does it take to change the ownership of a regional center by filing a Form I-924? We do not publish separate processing times for I-924 amendments related to ownership changes. Processing times for I-924s generally are available on our website at the URL on your screen. When will you publish the quarterly I-526 case status reports again? The report has not been updated since Q1 of fiscal year 2020. We stopped publishing the 526 specific report because those statistics are covered by the agency's collective forms reporting. Fiscal year 2020 data, which includes I-526 data, is available through Q2 of fiscal year 2020 and can be found at the URL on your screen. Where can I find the processing times for EB-5 cases? Processing times are available on the USCIS Processing Times webpage at the URL on your screen. This page is updated on a monthly basis with the current processing times for individual form types processed at IPO. Why are delays being encountered with sending an approved I-526 immigrant petition by alien investor to the National Visa Center, or NVC? The pandemic and USCIS's hiring freeze affected IPO staffing levels and workplace procedures. Early in the shift to pandemic-safe operations, IPO experienced operational deficits, which temporarily impacted our program's ability to transition cases to the NVC. This deficit has been identified, and we are actively working to address this concern. It appears that USCIS is now back to scheduling biometrics for I-829 petitioners and dependents. However, it appears that USCIS has been scheduling the petitioners first and the dependents later. Can biometrics appointments for family members be consolidated? When USCIS offices temporarily closed on March 13, 2020, the biometric scheduling system canceled all pending appointments. When Application Support Center reopened, the system automatically started scheduling the petitioners. We are actively trying to schedule all family members on the same day when it is possible. Is USCIS considering implementing a premium processing fee for EB-5? USCIS is not considering implementing premium processing for the EB-5 Investor Program petitions and applications at this time. Do the estimated time range, months, in the revised USCIS check case processing times page for Form I-526 continue to represent the median and 93rd percentile of recently adjudicated I-526s from China and other areas? Yes. I hope the information we have covered today has been helpful. You will find the information discussed today, including this video, on the USCIS website. We appreciate your interest in the EB-5 program and the opportunity to engage with you.